quickly revise what we did in the last lecture and then we can proceed further. So in the last lecture, we did, we concluded, heard, and finally decided. This was the concluding point of the concept of heard and finally decided. We did a few things. The first thing that we understood was that if there is an ex parte decree or an ex parte proceeding, will it be considered to be heard and finally deciding? So if there is an ex parte decree or if there are ex parte proceedings, will it be considered to be heard and finally decided? The answer to this question was yes, if requirements of CPC are followed. So we went on to understand Order 9, Rule 6, 1A, 6A. Okay? Then we went on to understand Order 8, Rule 10. Then we went on to understand Order 37, Rule 5, Sub Rule 3. These all things we went on to understand in a greater detail. And I told you ultimately that even in these cases, if you are passing this is Rule 3, Sub Rule 5. Huh? This is Rule 3, Sub Rule 5. Rule 3, Sub Rule 5. Fine. And ultimately, we came to a conclusion that even if it is passed, even if an ex parte decree is passed, and if the legal requirement of CPC are maintained or followed, in that case, it will be considered to be heard and finally decided, and res judicata will apply. So even if the case is falling under these ambits, in the ambit of the following provisions, it will be considered as heard and finally decided, and res judicata will apply. This is what we concluded. And then we went on to discuss what about compromise decree? Is compromise decree, can we say that compromise decree is heard and finally decided? Can we say compromise decree is heard and finally decided? The answer to this question was no. I said that you cannot say that the compromise decree is heard and finally decided because because decisions in a compromise decree are not on merits. Rather, two parties are coming to a particular compromise and they are closing the matter. So in that case, you cannot say that the matter has been heard on merits or evidences are taken and ultimately the matter has been closed on merits. You cannot say that. Rather, matter has been closed after two parties are coming to a compromise or after two parties are coming on a single ground. So that is the reason this is not heard and finally decided. And since it is not heard and finally decided, res judicata will not apply. Now the question is that since res judicata is not applying, can we file a subsequent suit for compromise decree, for challenging the compromise decree? Can we file subsequent suit? What do you guys think? Even though, bataiye, what do you guys think? Is the subsequent suit barred or not? Yes, Ahmed.
I think it will be barred because at the end it's the compromise decree that has come by the consent of both the parties.
Okay. Yes, Mansi.
Sir, it will be barred, but under Order 23, Rule 3A.
Correct. So compromise decree is not heard and finally decided, and subsequent suit challenging the compromise decree is barred. But it is not barred by the rigors of res judicata, but it is barred under Order 23, Rule 3A. This is what we went on to understand while we were dealing with compromise decree. Then we went on to understand abatement. So what is abatement? I told you if one party dies, then ultimately the suit terminates and suit abates. Now the question is, when the suit terminates and suit abates. Now the question is whether this abatement will be considered as heard and finally decided. If the suit is decided on the basis of an abatement, can you say that it is heard and finally decided? I told you that no. Even in suit which is a victim of or which is a result of abatement, cannot be said heard and finally decided. It is not heard and finally decided, and res judicata will not apply. Now again the question is that if res judicata does not apply, that means you can file a subsequent suit. Now the question is there any other bar in the cases of abatement? The answer to this is yes. Even an abatement is barred, even a suit like challenging the abatement is barred under Order 22, Rule 9. Fine. These are the few things that we went on to understand. So in compromise and abatement, though res judicata is not applicable, but the subsequent suit is barred under some of the provisions of CPC. So a compromise decree is barred under Order 23 Rule 3A, abetment is barred under Order 22 Rule 9. Fine. Then thereafter we went on to discuss that arbitration, whether res judicata applies, whether Section 11 applies in arbitration, in the cases of arbitration. So I told you, see, Section 11 does not apply in the cases of arbitration. The reason being arbitration is a proceeding and Section 11 clearly mentions the word suit. So Section 11 is only applicable to suits. So Section 11 per se will not be applicable. But the concept of res judicata or the general principles of res judicata are wider than Section 11. So they will be applicable in for arbitration, but Section 11 will not be applicable. So Section 11 not applicable, but general principles of res judicata are applicable. Fine. This is what we went on to understand. So Section 11 not applicable. General principles of res judicata applicable. General principles applicable. Sir, ex parte decree and ex parte proceedings, no, they are not same thing. Ex parte decree is a result of the proceedings. Ex parte proceedings are when the proceedings are conducted ex parte. Fine. So general principles of res judicata will apply. Okay. With this, we ended our lecture. इतना ही हमने किया था last session में. Today we'll start with a few other things. So I have 3 things in mind. First, we'll complete all the explanations that we have studied. Then we'll move on to the concept of interim orders, whether in interim orders in a same suit res judicata is applicable. Then we'll move on to erroneous decision of law, and then ultimately writs, whether in writs res judicata is applicable, and also PIL. So these 3 things we'll go on to understand. अब आ जाइए explanation पे. Come to explanation 4. Explanation 4 तो we guys have we have understood, right? Explanation 4 we have understood. Anyone remembers explanation 4? Explanation
Yes,
4.
constructive res judicata.
Constructive res judicata.
Yep, constructive res judicata. So explanation 4 incorporates constructive res judicata. It says that what matter indirectly issue you ought to have been raised you should have been raised in the formal proceedings. If you haven't raised, then res judicata we'll deem it to be raised and res judicata will apply. That is what explanation 4 is trying to say. So we need not get into it. We have already done this. Then comes explanation 3. Now explanation 3 talks about matter and issue. And now how explanation 3 is worded. So explanation 3 is worded like this. In fact, you can learn explanation 3 like from this chart only. So explanation 3 is worded like this. The explanation 3 is trying to say that there is this one thing known as matter and issue. That there is one thing that is matter and issue. Fine. And matter and issue has directly and substantially. Matter and issue can be directly and substantial. Okay, it can be directly and substantially. Second thing, it can be collateral and incidental, right? Collateral and incidental. Now, if it is collateral and incidental, no res judicata is applicable. Correct? If it is directly and substantially, then 2 questions come. Whether it has been raised. If it has been raised, if you have raised it and ultimately they have been decided, the court has decided upon it, then direct res judicata will apply. Direct res judicata will apply. Okay. So now here you will have, for direct res judicata, you will have 2 cases. So there can be issues raised by one party and admitted by other. This is the first aspect that you can face. Issue raised by one party and admitted by another. Okay. And then issue raised by one party by one party and denied by another. And denied by another. Okay. So two sorts of things two sorts of two aspects are dealt. One is issue raised by one party and admitted by another. Res judicata again will applicable. Issue raised by one party and denied by another. Another direct res judicata will applicable, because here the issues are raised. So this is what explanation 3 is trying to say. Now come to explanation 3. Now then there comes a second aspect. Issues which are not raised. So ye to ho gaya raised. There can be issues which are not raised. So what will happen to them? What will happen to them? Issues which are matter directly and substantially an issue but are not raised. Tell me what will happen to them.
Constructive res judicata.
Correct. Constructive res judicata will apply. So here will be constructive res judicata. Okay. Now come to explanation 3. Are you guys in explanation 3?
Yes, sir.
Take a second. Fine. So the matter above to must in for the matter above referred to must in a former suit have been alleged by one party and either denied or admitted expressly or impliedly by the another. So issue has been raised by one party and it has either been admitted or it has either been denied by the another. So if these are the two situations, then it is a case of direct res judicata. Right. So this is what explanation 3 is trying to say. Fine. Now come to explanation 5. Yeah, the clear? Now come to explanation 5. Now explanation 5 says, let's read explanation 5. Come to explanation 5. Any relief claimed in a plaint which is not expressly granted by the decree shall for the purpose be deemed to have been refused. Shall for the purpose be deemed to have been refused. Now take for example, A is filing a suit against B. A is first claiming declaration of title. He's claiming declaration of title. Second relief, he is claiming possession of the property. Third relief, he is claiming mesne profits. What is mesne profits is basically during the time B had been in illegal possession of the house, profits which he could have earned or he has earned in during that time. For example, B was in illegal possession of the house for 1 year. So the profits that he earned, the rent that he could have received for 1 year will be paid to BA. Fine. So this is what is known as mesne profit. So one thing that he asked is for declaration. Second relief he asked for possession. Third for mesne profit. Court granted declaration. Court granted possession. Court was silent. It did not deny. It did not grant. But the court was silent in its decree regarding mesne profit. Fine. So what does this silence means? If the court is silent as to any relief in a decree, what does it mean? Or in a judgment, if the court is silent as to any decree, then what does it mean? It basically means that the court has refused that relief. Court has refused that relief. So in this case, it will mean that the court has refused mesne profits. So in this case, A will not receive mesne profit, but A will be entitled only to declaration and possession. So this is what explanation 5 tries to say. Explanation 5 says that if the court is silent as to any relief in a judgment, then that relief will be deemed to have been refused. It won't be granted. It will be said to be refused. So if the court is silent, then the relief will be deemed to be refused. Now, what is mesne profits? See, mesne profits is simple. Suppose there is this fellow B. He is in illegal possession of this property. Fine. And he is in illegal possession for about 2 years. A files a suit. A is legally entitled to this property. A files a suit to recover this property. Now A will not only be entitled to the recovery of possession of the property, rather A will also be entitled to the profits that have been earned by B during this 2 years from this land. That is what mesne profits means. Suppose B has earned rent, so A will be entitled to that rent of 2 years. Fine, this is what mesne profit means. Clear? So if the court is silent as to any relief, then it will be said to have been refused. Yes, Anukriti.
Sir, explanation 5 sir, refusal denial के बाद 3 day बस इतना ही कहा गया है
क्या बोल रहे हो आप? Not audible. No, not audible. Not audible. आपकी आवाज ठीक से नहीं आ रही. आपकी आवाज ठीक से नहीं आ रही. Yes, Viraj.
Sir, maximum duration of means profit is 3 years. Correct?
ऐसा कुछ नहीं है. There is no such period. Limitation is 3 years. ऐसा कोई पीरियड नहीं है. लिमिटेशन आपका लिमिटेशन के लिए आप सही हो, बट ऐसा सही नहीं जरूरी नहीं है. इट कैन बी फॉर एनी टाइम.
ओके सर, थैंक यू.
ठीक है. सो एक बार लिखिए एक्सप्लेनेशन 5 पे. कम टू एक्सप्लेनेशन 5. रुको एक बार लिख लीजिए अनुकृति, मैं आपका डाउट ले रहा हूँ बाद में. आप एक बार लिख लीजिए. सो व्हेन on a particular relief, the court is silent. The court in its judgment is silent. ठीक है. Then it will be deemed that the court has refused to grant that relief. ठीक है. तो मान लिया जाएगा कि कोर्ट ने ग्रांट नहीं किया है, रिफ्यूज कर दिया है. कोर्ट हैज नॉट ग्रांटेड द रिलीफ. नाउ कम टू एक्सप्लेनेशन 6. आर यू गाइस ऑन एक्सप्लेनेशन 6? सर आई वाज आस्किंग एक्सप्लेनेशन 5 में एक्सप्रेसली ग्रांट की बात की गई है, डिनायल के लिए तो लिखा ही नहीं है. ये पार्टीज के बारे में बात कर रहा है ना. पार्टीज के बारे में बात कर रहे हैं ना. आप जो कंफ्यूजन है आपका एक्सप्लेनेशन 3 से कंफ्यूजन है. पार्टीज एडमिट और डिनाई करते हैं, कोर्ट तो ग्रांट या रिफ्यूज करता है ना. फाइन, ये एक्सप्लेनेशन 5 कोर्ट के बारे में बात कर रहा है. कम टू एक्सप्लेनेशन 6 नाउ. ठीक है. नाउ आ जाइए एक्सप्लेनेशन 6. लेट्स रीड एक्सप्लेनेशन 6. Come to explanation 6. Are you guys on explanation 6?
Yes, sir.
ठीक है. अब आ जाइए. Where persons litigate bona fide in respect of a public right or a private right. तो आप समझो, public right or a private right. People are litigating in respect of public right or a private right. ठीक है भाई. ठीक है. Public right or private right claimed in common for themselves and others, which is common for themselves and another, which is claimed in common. claimed in common for themselves and another. Themselves and others. Okay, so this public or private right is common for themselves and another. Okay, let's read further. All persons interested in such right shall, for the purpose, be deemed to claim under the person so litigating. Now try and understand what is happening. This you can say explanation 6 talks about a representative suit. A representative suit. So what is a representative suit? Suppose, consider that we are, say we have a hostel. All of us are staying in a hostel. We have an hostel, fine. And every night what happens? There is this fellow A. He plays loud music. He plays loud music. And ultimately he disrupts our sleep. He does not allow us to study. Ultimately, he infringes our right to enjoy the property. So A is infringing the right of entire. A is actually infringing the right of entire hostel. Now in hostel, say there are 100 people. So A is infringing right of 100 people by playing loud music. Okay. So now what do? Since A has committed this nuisance, this is an act of nuisance now. He is basically infringing our right to enjoy the property. So this is an act of nuisance. A has committed nuisance. So what do? I, as your teacher, I say that, see, you guys need not worry. I will file a suit against A. So I file a suit against A, and this is M. See, I am M. So I file a suit against A, and I am your representative. So basically, I am representing the entire hostel, and I file a suit against A as the representative of hostel. Fine. Yahan tak clear ho? Yahan tak clear ho? But
Yes, sir.
But what happens the moment I file a suit is dismissed. I am unable to prove A's nuisance. मैं A का nuisance prove ही नहीं कर पाता. Suit is dismissed. This is a former suit. So what happens? One of my student, he said that sir से तो कुछ नहीं होने वाला. Sir is useless. Let me try and let me file a suit again. So he files a subsequent suit. Say Anukriti. Anukriti files a subsequent suit against A. Now, a suit by Anukriti will also not be maintainable. This suit by Anukriti will also be barred by res judicata. Now, tell me why. Now, see, one thing that you have to understand is that when I was litigating, when M was litigating, he was litigating as a representative of the entire hostel, all 100 people. So we will deem that in the former suit, all 100 people have actually been the parties. Though M was only the person litigating on their behalf, but we will deem that all 100 people have been parties. सारे 100 के 100 लोगों ने ही litigate कर दिया है. So now Anukriti is one of the persons out of that 100 people. So if she files a subsequent suit, that will be barred by limitation. That will be barred by res judicata. And therefore, the court will dismiss that suit and the court will not proceed further. Fine. Because Anukriti was already there. Because M had already litigated on behalf of Anukriti. M ने तो ये 100 लोगों को represent किया ना. M had represented these 100 people. And in these 100 people, Anukriti was one of them. So this suit matter has been already been decided, and Anukriti in this suit was a party through M. So therefore, in this case, res judicata will be applicable, and this is what explanation 6 is trying to say. This is exactly what explanation 6 is trying to say. Explanation 6 is trying to say that when a person has in its representative capacity, he litigates anything, any right which is common to all of them, any public right or private right which is common to all of them. See, this is a private right which is common to all of them, which is common to all the 100 people. Right to enjoyment of a property is a private right, and which is common to all these 100 people. And here M is litigating on behalf of these 100 people. So now res judicata will apply in the subsequent suit, and we will deem that these guys, these 100 people, were party in the former suit. Fine. Is this clear? Yahan tak clear ho? So representative suit applies in plaintiff's case only. Yes, plaintiff can only be the representative. Fine. So this is your explanation 6. Now with this, we again come to one more aspect, whether this will be applicable to PIL. What about PIL? What about public interest litigation? What about public interest litigation? Whether explanation 6 applies to public interest litigation. Fine. What do you guys think? Whether explanation 6 applies to public interest litigation? ठीक है. Okay. Now see, PIL will be of two kinds. PIL can be of two kinds. See, if the petitioner himself, is also interested, if petitioner himself is also interested, that is, now when I say petitioner himself is also interested, that is petitioner's own right. That is petitioner's own right. Own right has been. That is petitioner's own right has also been violated. That is petitioner's own right has also been violated. Petitioner's own right has been violated. In that case, explanation 6 will apply. In that case, explanation 6 will apply. Because see, now here what is happening, the private right that is common to all of them, and that has been infringed. So in that case, explanation 6 will apply. But if PIL has been filed, if PIL has been filed, pro bono publico, in pro bono publico. Pro bono, what is pro bono publico? That is in public spirit. If PIL has been filed in pro bono publico, that is in public spirit, then explanation 6 will not apply. But अभी explanation 6 apply नहीं करेगा तो क्या apply करेगा? मुझे बताइए. If explanation 6 does not apply, then what will apply?
Broad principles of res judicata.
Yep. But broad principles of res judicata will apply. Of res judicata will apply. Okay. So this is regarding public interest litigation. If petitioner himself is interested, then explanation 6 will apply. If petitioner himself is not interested, rather the PIL has been filed in as a pro bono publico, then explanation 6 will not apply, but broad principles of res judicata will be applicable. Yes, Sarthak.
Sir, what should we prefer in cases of MCQ?
MCQ, broad principles. Okay. MCQ explanation 6 is not applicable, broad principles. Fine. Yeah, broad. What are broad principles of res judicata? Broad principles matlab जैसे नेचुरल जस्टिस के सारे प्रिंसिपल्स होते हैं, वैसे ब्रॉड प्रिंसिपल्स ऑफ रेस जुडिकाटा सेक्शन 11 में ही थोड़ा ही है रेस जुडिकाटा. रेस जुडिकाटा इज बिगर देन दैट. फाइन. ये हो गया आपका एक्सप्लेनेशन 6. यस आयुष.
हाँ सर, तो अगर हाई कोर्ट में अगर कोई रिट डालता है तो फिर सुप्रीम कोर्ट में नहीं डाल सकता उसी इशू को लेकर?
हाँ, वो नहीं हो सकता. रेस
सर फिर क्या
जुडिकाटा
होगा, वो डिसमिस हो गया तो फिर फाइनल?
वो फाइनल है. रेस जुडिकाटा अपील कर सकते हो, रिट नहीं डाल सकते.
रिट
उसके
के
अगेंस्ट अपील कर सकते हो, रिट नहीं डाल सकते. वो मैं आगे बता रहा हूँ. वो मैं आगे, उसमें केस है दरिया वर्सेस स्टेट ऑफ यूपी, एंड इसलिए नहीं डाल सकते क्योंकि रिट सेम वो है, मैटर है, सेम मैटर इन इशू. ठीक. सो दिस इज एक्सप्लेनेशन 6. So explanation 6 is basically talking about a representative suit. 6 is talking about a representative suit. Now, important thing that comes is whether there can be representative defendants. No, there cannot. There can be representative defendants in the sense that you can have defendants as representatives through agents or someone else, but a representative, you cannot initiate a defense through representatives. Why cannot you initiate a defense through representatives? Because a defendant is not chosen, does not chooses to be in a suit through his whims and fancies, through his own will. Rather, plaintiff is the one who is instituting the suit, and he is the one who is choosing, he is the one who is making him come in the suit, or making him enter his defense. So therefore he cannot sue in a representative, he cannot defend in a representative capacity. Okay. What if there is one plaintiff and 100 defendant? 100 defendants are annoying one plaintiff. That is what you are saying. He will have to file. The plaintiff will have to file against all the defendants. Plaintiff cannot say na ki since, suppose, come on, let's take this example. What if there is one plaintiff and 100 defendants? Now say this is a hostel. Hostel is making a lot of noise. 100 students are there. Fine. And this is A. He is studying quietly. He gets really annoyed that these guys are causing nuisance. So he files a suit. Now here he will have to file a suit against all the parties that are actually infringing his right. He cannot just file a suit against M. M hasn't declared, he cannot possibly know that M is the representative. Fine. So that is the reason he will have to implead all the 100 students. But if there is a situation wherein M takes the entire responsibility of the hostel, and he says that anything happens, then I am the person who will be responsible. In that case, then A can only file a suit against M. That is another issue that happens in most of the hostels, that anything that is happening in the premises, that the school management is responsible for that. So in that case, you generally sue the school management. But if that is not the case, you will have to sue all the people that were doing nuisance or infringing your right. Fine. Because see, here you can choose your plaintiffs. You cannot choose your defendants. Sorry, you cannot. Yeah, correct too, man. Yeah, I am correct. Sorry. You can choose your plaintiffs. You cannot choose your defendants. Means that you don't have that liberty whether the defense can be in as a representative. Can be, this person can be my co-defendant, this person cannot be my co-defendant. That liberty you don't have while you are initiating a defense. Fine. Is this clear? आगे बढ़े. Come to explanation 7 now. Explanation 7 talks about execution proceeding. Execution proceedings. ठीक है. Explanation 7 आपका execution proceedings के बारे में बात करता है. Let us clearly analyze what execution proceedings is. What are they talking about? Just give me a second. Fine. Let us see what they are talking about. Come to explanation 7. आ जाइए. Let's read. वो explanation 7 पे. A provision of this section shall apply to a proceedings for execution of a decree, and references in this section to any suit, issue, or suit, issue, or former suit shall be construed as references respectively to a proceedings proceedings for the execution of a decree, question arising in such proceedings, and former proceeding for execution. So what they are talking about, simply they are saying that see, section 11 will be applicable to execution proceedings also. Now one question that arises is that section 11 is applicable. We understand that section 11 is applicable. एक सेकंड दे दो, इसमें कुछ एरर है. Just give me a second. Okay. So we understand that section 11 is applicable to execution proceedings, but what are you going to do of the term? What are you going to do of the term suit mentioned in the main section? The word suit hai, that has been mentioned in the main section, how do you replace it? So explanation 7 clarifies it, that the word suit, for the purposes of execution, will mean execution proceedings of execution. So word suit will mean proceedings of execution. This is the first thing. Proceedings of execution of a decree. Okay. Then second comes issues. Now see, there are no issues in execution proceedings. So material and directly substantial issue, what does that mean? So they have said that see, issues will mean questions that are arising in execution proceedings. Questions arising in execution proceedings. Fine. Former suit. With respect to execution, what will it mean? It will mean former proceeding. So basically what explanation 7 is trying to do, explanation 7 is trying to modify some aspect of the main section. Since the word suit has been given, it says that for the purposes of execution, let us read it as proceedings of execution of decree. Issue लिखा है, execution proceedings के लिए हम इसको पढ़ेंगे question arising in execution of proceedings. Former suit, for the purpose of execution, we will read it as former proceeding. So this is what they are trying to do. They are basically trying to somehow modify the words only for the purpose of execution. Now the question that arises is that how will res judicata apply in execution proceedings? कैसे apply होगा execution proceeding में? How will res judicata be applicable in the cases of execution proceedings? So say suppose such a thing happens. Should I proceed further? Fine. अब देखो. Suppose A is a decree holder. A decree holder is a person in whose favor decree has been passed. Say A is a decree holder. ठीक है. And he applies to court for execution of decree. So here somewhere he applies to court for execution. He applies to court for execution. Fine. Now A requests the court to sell B's house. So A is requesting the court to sell B's house. So ये जो house है उसको request कर रहा है कि sell B's house worth rupees 1 crore. Sell this house which is worth rupees 1 crore. Worth rupees 1 crore. ठीक है. Now in these proceedings, B makes a contention. B contends that see, boss, you are selling my house which is worth rupees 1 crore, but I have paid 90 crores. I have paid 90 crores only 10 lakh remain. So for only 10 lakh, why are you selling my house for 1 crore? You have got a decree of 1 crore. I agree. And out of that 1 crore, I have paid 90 lakhs, 90 crore, 90 lakhs. I have paid 90 lakhs. Only 10 lakh remain. So for that 10 lakh, why are you selling my house of 1 crore? What is the point of selling my house of 1 crore? Now, court ultimately decides this issue, that how much amount is remaining to be paid in this decree. And court ultimately hears and finally decides. Hears and finally decides that 10 lakh remain and house is not supposed to be sold. That सिर्फ 10 लाख बचे हैं और घर बेचने की जरूरत है ही नहीं क्योंकि सिर्फ 10 लाख बचे हैं. Why to sell a house of 1 crore? Doesn't make sense. Then what happens? So this execution proceeding is ultimately decided in favor of B. Okay, this is decided in favor of B. So what happens? A gets angry. A files a suit against B, claiming that 1 crore is remaining in this decree. So this is a former suit. Let's call this former proceedings. And then this is a subsequent suit. Now, because of explanation 7, tell me whether this suit is barred or not.
Yes, sir, barred.
Now, the reason this is barred, because matter in issue in both cases is same. Issue is same. The question as to the amount that is pending from the decree has already been decided in the execution proceedings. So it has been already closed in the execution proceedings. So it need not be reopened again. So therefore, res judicata will apply in this case, and the subsequent suit will be barred by limitation. Res judicata. Subsequent suit will be barred by res judicata. So this is what that res judicata is also applicable in execution proceedings. This is because of explanation 7, which reaffirms that res judicata is applicable in execution proceedings also. ठीक है, तो अब एक बार देखो, explanations आपके बहुत important है. Explanation 3, डायरेक्ट रेस जुडिकाटा, ठीक है, डायरेक्ट आरजे, एडमिशन एंड डिनायल. 2 things that have been mentioned. Tell me what is explanation 4?
Constructive res judicata.
Constructive res judicata.
And explanation 5? 5 बताओ.
Sir, silent when the court is silent.
Yep. Then the court is silent. Then refuse. Silent is equals to refusal. ठीक है. Then comes explanation 6.
Representative suit.
Correct. Representative suit. ठीक है. Then comes explanation 7. Execution proceedings. Explanation 8 बताओ. Explanation 8 नहीं याद?
Limited jurisdiction.
Yep. Limited jurisdiction. Explanation 8 is limited jurisdiction. 8 is limited jurisdiction. Correct. तो ये था आपका explanations. अब एक और मैटर जो हमें डील करना है. Let's deal with that aspect. The question is that whether res judicata is applicable to issues in the same suit. Suppose is it applicable to interim issues in the same suit? So whether res judicata is applicable to interim issues in the same suit. Now, what does this mean? Now, say an issue, interim issue in these suits. Whether res judicata is applicable to interim issues in same suit. Now, what does this mean? Now, say suppose this is a suit. Here an issue has been raised. it has been decided by the court. And ultimately, can it be raised again here? Or res judicata will apply? In the same suit, can that issue be raised again or res judicata will apply? इसी इशू में यहां पर आप रेस कर सकते हो या रेस जुडिकाटा अप्लाई होगा? That is the question. See, try and understand. There are two kinds of interim issues. Interim issues, I'll tell you what is interim issue. Interim issues are the issues that have to be decided during the pendency of the suit. You can have two kinds of interim issues. One interim issue is a dynamic interim issue, which keeps on changing as new facts arise. For example, injunction. Injunction is an issue which is dynamic in nature. So whenever a new fact arises, you can again file an application of injunction. So if there is a dynamic interim issue on which is based upon any new fact, as a new fact arises, it changes. The matter of the issue completely changes, or the main essence or the matter is directly and substantially an issue of that particular interim issue completely changes. So if it is a dynamic issue, in that case, res judicata will not apply. But if it is a static issue, what are static issues now? If it is a static issue, then res judicata will apply. Now, what are static issues? Static issues are those issues which are not subject to change. For example, an issue which says that whether this court has jurisdiction. This court has jurisdiction. Issues whether suit is barred by limitation. Whether suit is barred by limitation. By limitation. Okay. These are static issues. Means that, see, these in the entire suit, they will remain the same. In the entire suit, the answer to the question whether the court has jurisdiction will remain the same. In the entire suit, whether the suit is barred by limitation, the answer to this will remain the same. पूरे suit में इसका जवाब, whether the suit is barred by limitation, will remain the same. In the entire suit, the answer to the question whether this court has jurisdiction will remain the same. So these issues are static issues. इसको हम बोलते हैं static issues. So in static issues, res judicata will apply because they are not subject to any change. They will not encounter any new facts. But on the other hand, there are certain issues which are, say, dynamic in nature. Say injunction. Say suppose this is a suit. Here an injunction application was filed. And injunction application was filed and the same was dismissed. So the party filed the injunction application again. And this time the party said that the subject matter in question, which we are subject matter in issue, is in danger, is in great danger. Is in great danger. Earlier it was not in great danger. That is the reason the injunction was dismissed. Now there is a change of fact. There is a change of fact. Now the subject matter is in great danger. So there is a change of fact, and this issue is known as, when there is a change of fact, such issues are known as dynamic issues. Fine. So in this case, the subsequent issue of injunction will be maintainable and res judicata will not apply. Will not apply. ठीक है. और कौन से dynamic issues हो सकते हैं? Attachment. Attachment is a dynamic issue. If you want to attach a property of a defendant, that is also a dynamic issue. Say suppose you see, there are two grounds for attaching a particular person's property. The first ground for attachment is that he is about to sell his property. वो अपनी property बेचने वाला है, विजय माल्या बन रहा है. He is about to go out of the country. He is about to sell his property. So before selling his property, you are attaching his property. Now, this is a dynamic issue. This can change. For example, at one moment, he was not willing to go to another country. And today he is willing to go to another country. And he is willing to sell his entire property to evade the execution of the decree. So he's just selling the property. This is again a dynamic issue. So in this dynamic issue, res judicata will not apply because the facts are subject to changes. So in that case, to make res judicata applicable will be of no sense. Fine. So this is what interim issues mean. So those issues, yahan tak clear ho? Till here you guys are clear, right?
Yes, sir.
Okay. The issue is likhiye, the issue is whether res judicata applies upon an issue determined in same suit, upon an issue determined in the same suit, same suit. That is, if some issue was raised at a particular stage, stage of the suit, and was heard and finally decided, if the same issue is raised at a subsequent stage, whether res judicata will apply. The answer lies in the fact as to whether the determination of that issue is dependent upon certain facts which are not subject to change, in such cases res judicata will apply. अब example कौन से issues which are not subject to change? Issue of bar of limitation not subject to change, it will limitation end tak wahi rahega. Issue of lack of jurisdiction not subject to change. Issue of impediment of party, whether a party has to be added or not, not subject to change. These are the three issues. These are three main issues which are not subject to change. Fine. These will not change in the entire suit proceedings. खत्म नहीं होंगे suit proceedings. अब आगे बढ़ते हैं. ठीक है. Should I proceed?
No, sir.
No or yes? No.
Yes.
Yes, sir.
Wait. किसी को लिखना तो नहीं है ना, आगे बढ़ूं मैं? ठीक है. Fine. Okay. So अभी दूसरा second part, which is dynamic issues. इनको बोलते हैं dynamic issues. पीछे आपने देखे वो थे static. They were remaining same during the entire period, Now these issues are dynamic issues. They differ. So however, if the factor if the factor on which determination of issue is dependent is one such as to likely is one such which is likely to change, is one such which is likely to change with passage of time. ठीक है? Then res judicata will not apply. Will not apply. Example: injunction, attachment of some property, arrest of your defendant, of the defendant. ठीक है? In these cases, facts are subject to change. Therefore, in these cases, it will not. Your res judicata will not apply. ठीक है? With this, we are done with today's session. कल continue करेंगे res judicata on writs and res judicata on erroneous question of law. Yes, Anukriti.
Sir, am I audible?
You're audible now.
Sir, I wanted to ask that the arrest of the defendant क्या है?
Arrest of the defendant क्यों है?
Yes, sir. What is this arrest of defendant?
जब arrest in the cases of a defendant अगर भाग रहा है देश छोड़ के, तो आप उसको अरेस्ट करोगे so that he does not run away from the country, he does not avoid this suit. तो वो जैसे माल्या जी हो हैं, उन्हें 500 करोड़ देने, 5000 करोड़ देने, and he is trying to flee India. Before that, plaintiff gets an order of arrest of Malia ji. Until the suit is decided, he has to be there. So that is arresting. Fine.
Yes, sir. Thank you, sir.
सर 9000 करोड़ है, 9000 करोड़ तो है, तो शायद 4000 तो इंटरेस्ट है ना. अच्छा, एक्सप्लेनेशन 2 प्लीज. एक्सप्लेनेशन 2 अभी नहीं, एक्सप्लेनेशन 2 बाद में पड़ेगा. सर सेकंड एग्जांपल क्या है? सेकंड एग्जांपल इज अटैचमेंट ऑफ सम प्रॉपर्टी ऑफ डिफेंडेंट. ठीक है सर, प्लीज शो एक्सप्लेनेशन साइड. नहीं, यू डिडंट मिस इट, वी डिडंट कवर ओनली ना. सर प्लीज शो एक्सप्लेनेशन स्लाइड वंस. व्हिच एक्सप्लेनेशन? yes Sarthak, this one. yes Sarthak.
सर इंटरिम ऑर्डर्स में अगर एमसीक्यू आ जाए तो क्या मार्क करना है?
इंटरिम ऑर्डर्स में res judicata will not apply. ठीक है?
ओके सर.
सॉरी, इंटरिम ऑर्डर्स में res judicata will apply. सॉरी, res judicata will apply. उसमें res judicata will apply करो.
ओके सर.
उसमें yes करोगे. Sir, in MCQ also, correct answer is res judicata will not be applicable. Yes, it is correct. In MCQ, that is correct. Res judicata is not applicable in compromise and abatement suit. That is correct in MCQ. Okay. Sir, I thought, okay, sir. Sir, in second example, क्या है? Second example तो यही है ना, नीरज, आपका attachment. ये ना, ये पूछ रहे हैं ना second example आप?
जी सर, हो गया.
ठीक है. Explanation 2 वो cover नहीं किया हमने. Sir, please show the explanation side. Explanation side. This is the explanation side. Shashank, this is the side you are talking about? Slide, sorry. This is the slide you are talking about? ठीक है, चलिए guys, let's end it. Tomorrow we'll deal with 3 situations. We'll deal with 3 things. Tomorrow we'll first deal with this. 3 चीजों से हमें deal करना है. Tomorrow we'll deal with writs, erroneous question of law, then appeals if time permits, and then we'll be done with all the miscellaneous part of res judicata, and then we'll take one session on Ayodhya judgment and res judicata. What is the relation between what was the issue and how did the court actually come to a conclusion? Fine. चलिए. Yes, Anukriti. अच्छा आपने तो बोल दिया. हाँ जी पूछिए.
इश्यूज में res judicata में लगता है इंटरिम ऑर्डर.
इंटरिम ऑर्डर और इंटरिम इशू एक ही है. ठीक है. यस आयुष.
सर अगर कोई कॉन्ट्रैक्ट का ब्रीच होता है सर उसमें सीपीसी में किस पे वो लगा सकते हैं?
73 में कॉन्ट्रैक्ट के
सर तो वो स्पेसिफिक परफॉर्मेंस के लिए तो स्पेसिफिक परफॉर्मेंस एक्ट से लगाना पड़ेगा ना?
स्पेसिफिक परफॉर्मेंस मांग रहे हैं और डैमेज मांग रहे हो?
सर दोनों चाहिए.
दोनों चाहिए तो स्पेसिफिक परफॉर्मेंस भी मांगोगे, वो भी डैमेज भी. स्पेसिफिक परफॉर्मेंस एक्ट से ही जाओगे, सेक्शन 10 से.
यस.
ठीक है.
थैंक यू.
Do we have a class on Hindu law? Yes, today we will have a class on Hindu law. CRPC, we have only 1 or 2 sessions remaining. I'll complete it on a Saturday. Because they have told me to start with Hindu law because you guys have your tests scheduled. तो उस हिसाब से मैं हिंदू लॉ से स्टार्ट करूंगा आज इवनिंग. ठीक है. चलिए सर एक वैसे यार वीडियोस सेम डे अपलोड नहीं हो रही क्या? दे आर गेटिंग अपलोडेड विद इन 24 आवर्स ना नाउ. But
सर 2 दिन तो लगते हैं सर, 2 दिन 3 दिन ऐसा लग जाता है.
लग जा रहा है क्या टाइम?
सर वीकेंड पे लग जाता है लेकिन ऐसे तो नॉर्मली हो जा रहा है सर 10 बजे के बाद.
वीकेंड हाँ वीकेंड पे इज नॉट अवेलेबल. वीकेंड पे इज नॉट अवेलेबल बट आई विल टेल मैं उसे कम्युनिकेट करता. ठीक है चलिए.
थैंक यू सर. सर एचएसए पढ़ाएंगे आज?
एचएसए नहीं, अनकोडिफाइड.
हाँ जी ठीक.
अनकोडिफाइड जो आपका रह गया था बीच का.
ओके थैंक यू सर.
5 है वैसे तो. इट्स एट 5:30. चलिए ठीक है. See you in the evening guys. Bye.